Thank you, everyone, for tuning in again to our labor and employment podcast called Workplace Issues in Atlantic Canada, Legal Perspective. I'm your host, Rick Dunlop. I'm a partner in the Halifax, Nova Scotia office of Stuart McKelvey, and I'm the practice group leader. Joining me today are my colleagues and fellow lawyers Annie Gray and Dante Manna, who will be talking about the Federal Pay Equity Act and the regulations. And I just want to provide a little background to my very accomplished colleagues. So first off, we have Annie Gray, and as I know from working with Annie, she brings a passion to problem solving. She graduated from the University of New Brunswick with an LLB with distinction in 2012, and she received numerous accolades. For example, the Lord Beaverbrook Scholarship in Law, the prize in evidence, the prize in property, the prize in contracts. She also got a scholarship in English. Not only that, but Annie was a clerk at both the New Brunswick and Nova Scotia Court of Appeals, 3 years in total, and very, very helpful. And it's a big deal when you're off to court and you can rely upon Annie Gray's experience. And then there's Dante. And Dante took a while to get to the law, but he got there. Dante decided that it would be a good idea to do a PhD in mathematics and was a former tenure-track mathematics professor. And during the pandemic, while I was at home being a math teacher to my then grade one-year-old, I asked him to provide me some grade one level math problems, and he wasn't that helpful because it was too simple for him. But anyway, I'm kidding. Dante actually is wonderful at explaining complex concepts. He has the Osgood Certificate in Pension Law in 2017, and this was an intensive curriculum covering corporate and institutional pension issues. And Dante is a leading practitioner, or a leading practice innovation expert in labor and employment. And he always is looking for better, more efficient ways to do things, which we are very thankful for. So I guess we're talking about federal employment equity, and I'm sure we'll get into the math later. But when I was looking at the regulations, I saw a lot of seemingly math equations, but I'm sure, Dante, you can sort of, from a big picture perspective, just let us know, what is this Federal Pay Equity Act, and what has it changed?
Sure. Thanks, Rick, and thanks for the introduction. We will get to the math formulas, but in terms of the big changes, there are really three big changes. One is the new act. Secondly, there's a new approach to pay equity. And thirdly, there's the new Pay Equity Commission. So I'll talk a little bit about each of those three. The new act is the Pay Equity Act. It was passed a while ago, and you may have heard of it back then, but as of last week, we now know it comes into force on August 31st, 2021. And when it does so, it will apply to federally regulated employers, including not just federal public servants, but also federal crown corporations, as well as federally regulated private sector employers in industries such as transport, telecom and broadcasting, banking. The Pay Equity Act will require all those employers to take a proactive approach to correct gender wage gaps within their organization by creating a pay equity plan. And when I say pay equity here, I mean pay equity on the basis of gender for their organization, which must be finalized no later than September 3rd, 2024. And if the pay equity plan requires compensation increases to close the wage gender gap, the increased compensation must start on that date, on September 3rd, 2024. So the new approach, what's currently the case in federal employment in pay equity, is that pay equity is largely complaint driven. In other words, under the current system, If a woman feels she's the victim of discriminatory pay practices on the basis of her gender, she has the onus to file a complaint and has to show that she's paid less than a male employee in her establishment who performs work of equal value. And if there are no complaints like that, then by default, we don't have any discriminatory pay practice. But the new pay equity system reverses that notion and reverses the onus. So the new approach is to start with the assumption that there is a gender wage gap, and that this exists because women's work, or work that's stereotypically considered to be women's, is generally and traditionally undervalued, and therefore this puts the onus on the employer on a periodic and ongoing basis under the Act to show that its payment structure provides female-dominated job classes equal pay for work of equal value. And it's job classes rather than individuals. So job classes are what must be shown to be compensated fairly. So it's going to be more work for employers instead of waiting for a complaint to come up. The new system is very robust. It's highly prescribed. And when you look at the process and the steps that go into the process, and Annie's going to give you some more detail on that later, it does amount to some extra work for employers, not the least of which is that many employers will be required to collaborate with their employees, or with any unions if there's a union, in the process of coming up with the pay equity plan. On the other hand, there may be more certainty in that once there is a pay equity plan, that serves as a measure of confirmation that the employer's compensation is generally not discriminatory. So as opposed to the current system, where not having any pay equity complaints is not really such explicit confirmation. That is a bit of a silver lining in all the extra work that employers will have to do and the costs. So thirdly, the new commission. There are some administrative changes as well. There's a new pay equity division within the Federal Human Rights Commission and a new pay equity commissioner to lead and administer the program. The commissioner's name is Karen Jensen. She's a former practicing employer's side labor lawyer, but she's also been a member of the Canadian Human Rights Tribunal for several years. And the commission, now has its own webpage with some tools and resources on there, which I noticed just in passing recently had a fraud warning when you clicked on it. Apparently there were some phishing emails going around. So as I always say, you're nobody till somebody impersonates you to commit fraud. So really they must have made it. But the idea, I think, in creating that new body and creating the commission is to lend an air of permanence to the pay equity legislation, as if, this new system will be here to stay for the foreseeable future, as opposed to just here until the government changes. So those are the three big changes: the new act, new approach, and new commission.
Okay, thanks, Dante. So Annie, tell us about the scheme and the various timelines that are outlined in the presumably the act and the regulations.
Yeah, certainly. Thank you, Rick, and thank you again for the wonderful introduction. So jumping right in, Dante touched a little bit on what we can expect for timelines. So last week, we finally got the announcement. The Pay Equity Act has been in existence, having received royal assent back in 2018. So we've been waiting for a while with some pandemic-related delays to find out when this was actually going to come into effect and the deadlines would happen. So we learned last week that August 31st is the big day when the act and the regulations come into force. And then with that come a few timelines. And Dante mentioned that the big overarching 3-year timeline in which employers have to get their pay equity plan established and in place, ready to take the pay equity actions that they need to achieve the goals of the act. So if, assuming that you as a federal employer come within the act on the date that it comes into force on August 31st, then September 3rd, 2024 is the big golden deadline to have your plan ready. But the first deadline that comes up is November 1st, 2021. And that's when employers need to post in the workplace a notice outlining for their employees all of their obligations under the Act. So one of the resources that the Pay Equity Commission has on their apparently impersonated website is they have templates that sort of give an idea of the outlines that you have to have when you post this notice. And last week when we received word, when the government posted that the coming into force date for the Act and regulations, they also published the final version of the regulations. So previous to that, last November, there had been draft regulations released and there were consultations that followed that. So last week was also the first time that we saw the final version of the regulations. And that clarified a few things, specifically in reference to deadlines. One of them being that this notice that has to be posted needs to remain posted until your pay equity plan is finalized. So there's that sort of constant reminder in the workplace of what those obligations are and what employees can expect from a pay equity perspective. And another interesting thing is that some deadlines were removed as part of the consultation process. So previously, employers had to work fairly quickly to decide whether they were going to apply to the commissioner for some different rules to apply. So one of those pertains to the Pay Equity Committee and the Pay Equity Plan. So every legal entity is required to have their own pay equity plan. But you can apply under the Act to have multiple plans. So given the scope by definition of a lot of federal employers' businesses from coast to coast, you can envision a lot of scenarios where it's probably going to be a bit unwieldy to have a single plan cover the entire country and all of the different bargaining units that compose that employer. So there is potential under the Act to apply to be able to have permission to have separate plans. And the initial idea was that there would be 1 year in which to make that application. That deadline is now gone under the regulations, though it's a good idea to act quickly. So there's a little bit more flexibility that way. And the commission has also released some guidelines on what that application should look like and what kind of applications are likely to be successful and which are not. The overarching considerations, as you might expect, are whether having multiple plans would still fulfill the circumstances of the Act. So if you attempt to have different plans because you've got one bargaining unit that sort of focuses on a primarily male labor force, and another one that has a primarily female office component, you're unlikely to get approval to have those two be separated and have a lack of comparison across genders. But if you're looking to capture sort of regional differences where you've got a good basis of male and female comparators, that's more likely to have some success. So the responsibility for making these plans, as Dante alluded to, is either employer-driven or committee-driven. So if your workplace has more than 100 employees on average, and the Act is specific on how to calculate that, or if you've got any unionized employees as part of your workplace, then you need to have a pay equity committee who looks after creating that plan or those plans. And there's some very specific rules in terms of what that composition has to look like. So there's got to be a bit of pre-planning to sort of identify who's going to represent the employer. And also there has to be a minimum of 3 people on the committee. And there has to be 50% minimum women. So you've got to fill a few different buckets at the same time. There have to be representatives for each bargaining agent, and non-unionized employees are able to vote to have their own representatives. So it's got to be a diverse and representative group with a few different moving pieces. So that is a good part to start planning and getting in place now in order to get moving on that plan. And in order to make the pay equity plan to achieve the kind of pay equity that Dante has described for us, the committee has some broad overarching goals. So they need to identify those job classes that we've said are key. They need to determine the value of work performed by those job classes. And they need to identify the compensation, how people are paid for that work that they do, then compare that pay, and then identify where the wage gaps are. And that's where we get into a bit more of that math and those moving pieces. And I don't know if you wanted to maybe jump in around this point, Dante, or not. But
Yeah, Dante, please, and remember, be sensitive to my limited math abilities.
Happy to. And I'll just underscore, that the real important and immediate parts of the decision-making process are the ones that Annie's already covered. So I'm not, I won't talk about those in detail, but we will be summarizing the process in a flow chart, which will provide as companion material to this podcast, so that everyone will have that available at a glance, to remind us of those important, especially the initial steps of deciding, whether a single plan or we need to apply for multiple plans, and then if we need a pay equity committee, if we meet the thresholds for the pay equity committee, who gets to be on the pay equity committee. Those are both really important pieces, and I think Annie's pretty well nailed those. But just to fill in some comments to provide a little color and detail about the actual process. So this is once you already have your pay equity committee, if you need one, or otherwise are setting up your pay equity plan. There are a few issues within the process that could be a little time consuming. And, if you have union or employee representatives on your pay equity committee, could be somewhat contentious. So I think, and I would encourage, any employers that if this act applies to you, to start considering these issues, particularly if there's a pay equity committee, so as to provide the employer representatives on the pay equity committee with some good direction in terms of which ways to advocate. Because the pay equity plan, once you have it, you're stuck with it for 5 years before you get the opportunity to update, with limited exceptions. And even then, it is the starting point for all future updates. So it really will be well worth getting right the first time. So there are a few issues that I'd like to discuss. One, gender predominance. Two, the determination of value of work. Three, the compensation of each job class. And then I will remark a bit about the math formulas. So just in terms of gender predominance, this is important to I don't think that job classes themselves will be very contentious, because they are the way that the employer sets them up to be. But in terms of whether a job class is female dominated or male dominated, or neither, that is something that could be potentially contentious. And of course, as the employer, the less female dominated job classes you have, the less work there is to do in a pay equity plan. But you do have to rationalize your reason for deciding that a job class is gender dominated one way or the other, or is not gender dominated. And the way it's defined in the Act, it seems to be set up so that it's more likely that a job class could be considered to be dominated by one gender or the other. So the way that you determine whether a job class is gender dominated is, first you look at the current inhabitants of the job class. If more than 60% are occupied by one gender, then the job class under the Act is defined as being dominated by that gender. Accordingly, if there is only one position in the job class, then no matter what that position, the person's gender would be, it could be considered gender dominated according to that person. But there are other ways to determine that a job class is gender dominated. It could be considered to be gender dominated if the majority of occupants historically has been 60% one gender or the other. And finally, it could be considered to be gender dominated if it's commonly associated with one gender or the other due to what the Act calls gender-based stereotyping. So there's a wide range under the Act of indicia that it could define a job class to be gender dominated by male or female, and it goes from the actual empirical to the very kind of subjective terms of stereotyping. in terms of how to determine whether a job is gender dominated by one or the other. And there could be difference of opinion. For example, let's say there was an IT manager position traditionally held by a woman in your organization, but is stereotyped to be a male occupation because it's IT, let's say. So should that be considered male or female? And it's worthwhile to start considering those sorts of issues with respect to your job classes to begin to understand which of the job classes are at risk of being considered to be female dominated, and to prepare accordingly. Now, in terms of determining value, so this is once you get past that first step, thought will need to be put into that because it involves assigning a value or a numerical number to each job class, but isn't necessarily the market value, so the actual wage associated with that position. And the way that this works is that at the end, you take the job values and you group them into classes, and then those tiers will be, among the tiers, will be the comparison between the male-dominated and the female-dominated job classes to determine whether there's any gender wage gap. So the valuation of the jobs is important in that way. So, for example, they don't have to be comparable in terms of the position responsibilities, but they are comparable in terms of value. Like if I'm a level 5 manager and if Annie's also a level 5 manager, that invites a direct comparison between our compensation, even though we may be in different job classes and performing different duties, because I may be managing all the laborers and Annie may be managing all the engineers in the workplace. So assigning values is something that the employer can start to consider independent of the pay equity committee's work. And then the other aspect that the employer can get started on is determining the compensation. So for one, compensation will include not just things like salary, but also benefits, plans, contributions, and sort of for executives in the organization, it would be all of their kind of executive incentives that are of monetary value. So the employer or the committee, if you have a committee, is also supposed to back out from that compensation any differences in compensation based on certain non-discriminatory factors. So the Act actually provides a list of factors that you consider to back out certain values from the compensation before you do that comparison to determine a gender wage gap. And so the things that you back out are differences in compensation with respect to things like seniority, length of service, merit-based compensation based on performance ratings, overtime, differences in pay based on geography, red circling, and there's a long list. But in terms of assigning, well, that $20,000 is due to the person living in Ontario instead of Atlantic Canada, that is something that will have to be agreed upon by the entire pay equity committee if there is one. So that, again, is something worth considering and worth instructing your pay equity committee representative, if you have one, in terms of providing an optimal outcome in terms of that compensation number. And then finally, at the point where we have values determined and we have compensation determined, here comes the math. So just to really simplify it for you, there are two choices. You can either do equal average, which involves averaging. Remember I said there were tiers, that the job classes break into tiers, and either averaging the male-dominated job classes in the tier versus the female-dominated job classes in the tier and figuring out whether there's a difference there, or you can be a little more complicated and do what's called the line method, where we actually plot a scatter plot within the tier of male-dominated and female-dominated job classes, value versus compensation, and draw regression lines through them, and then you measure the gap between the male-dominated regression line and the female-dominated regression line. And all I'll say about that is in terms of the choice between just averaging, and going to regression analysis is that I think most employers will just choose the averaging because it's a lot easier to understand. Also, you need a lot of data points to do a good regression line. Although, what an employer may consider is testing out both methods in advance to see which one works better and is more reasonable. And so, I think that can be done easily in Excel, or, if come to me and I can easily do it, bring me your data. But that's something worth considering, particularly if you have many job classes within a tier. And
Dante,
then at the end,
just one thing, and I'm sure everyone knows this, so maybe it's just for me, but what is, when you say regression analysis, just maybe provide me with a simple explanation what that is.
regression analysis would just be a straight line through a plot of points. So if you imagine the value of a particular job class on the x-axis and the compensation on the y-axis, every job class will have a value and a compensation that corresponds to a point on the graph. And a regression analysis means to fit a line to all the data points that would then appear on a scatter plot where the individual job classes would be dots.
Okay.
So there's your slightly higher than first grade math, Rick.
No,
but I'm sure
very
sooner
helpful.
or later CC will be able to explain that to you as well.
Sorry, I interrupted, Dante, but I just wanted to make sure.
That's fine. But the long and the short of it is, you can hand me your data and I'll let you know whether a regression works out or doesn't work out, as opposed to just the averaging. And then the second stage of it is that there are some formulas, and if you have a look at the formulas and you're mystified, fear not, because we've already looked at them for you. And just to summarize what the formulas tell you is, it will end up giving you a number between 0 and 1. So either the averages or the regression lines will have, if they have some sort of gap with the female underneath, then the number between 0 and 1 will tell you the proportion of that gap that needs to be made up in terms of the pay equity plan. So if the number that the formula spits out is 0.5, then that means you just have to bring the female job classes up halfway so you may not have to actually fill in the whole gap, depending on how that formula works out. And again, the formulas are publicly available. It's in the regulations, and you can start to work that out in Excel, or ask me to, forecast, how different scenarios may come out in the end.
Okay, thank you, Dante. Anything to add to that very helpful summary Dante provided?
I think Dante's covered the actual number pieces really well, and certainly he alluded to needing to go back to that plan every 5 years to sort of see where you are. And the Act and regulations also provide for yearly snapshots where you take a look to see if anything has changed, and you see where you are pay equity wise, and if anything has changed in terms of the values of the positions or the composition of male and female jobs. So there certainly is a complicated process up front that continues to be onerous going forward. So it really is a big shift in how we're going to look at pay equity and how often we're going to look at pay equity for federal employers.
Well, thank you. Thank you very much. I guess one thing is maybe we'll end on this. Recognizing that you've packed a lot of information in a short period of time and very effectively. Just wondering, what would you say would be the sort of three takeaways that you would tell federally regulated employers of all shapes and sizes what they need to do? What, when at the end of listening to all this, what do they need to do right now with respect to pay equity? And
I can take that
Yeah.
first.
Okay.
Happy to. First off, you want to determine whether and how the act applies to you. And feel free to ask us for help with any of that. And then it's worth turning your mind to some of the matters that we've begun discussing now. In particular, having a look at your compensation structure and making sure that it's well aligned, or starting to assess the ways in which it could be aligned, better aligned with the process we've just described. And then, thirdly, it's those regulatory requirements. I'll say that the posting of the notice by November 1st is a deadline, and that's the first deadline that comes up, and so that can be a focus.
Okay, wonderful. Annie, anything else to add?
I think that really that sums up a lot of it. I think making sure that you have your ducks in a row in terms of the information that you're going to want to feed that committee, particularly if you're an employer who's not going to be able to be in the driver's seat making your own plan. I think is to make sure you have things prepared to be as digestible as possible, because you're going to have to pay that committee for their time and give them a space to work. So their efficiency is in everyone's interest. So if anything you can do to bolster that is going to be really helpful.
No, that's great. Well, look, Annie and Dante, thanks so much. Very helpful, very informative, and it sounds complicated, but you definitely made it sound like it's not quite as daunting as maybe some may believe, but something that certainly federally regulated employers have to get going on and start thinking about and acting on. So thanks again, and we have more information on labor and employment issues at our website, Stuart McKelvey, and you can contact our lawyers. And please don't forget to subscribe to this series, Workplace Issues in Atlantic Canada, Legal Perspective. And certainly if you want to know about pay equity or any other topic, just let us know, and we will make sure that we do an informative podcast. And thanks again, and we'll see you next time.